Right. So good afternoon, everyone. So just to double check on all the equipments and the slides, if it's ready, then by 8 o'clock, I will just proceed to talk about this case law. It's actually about this siblings fighting for some estate belongs to the sister. And this case also involved, I think, wheels and all that. I mean, of course, I've done a lot of the shorts videos, right? I believe it doesn't touch on very thoroughly on all these matters. So hopefully this case law can give the public some idea of what the real life infighting among siblings happens and what do they fight in the court for. So it's a very interesting latest case as well. And it is a very fresh from the Owen case from the High Court. So it's actually a 2023 judgment. So I try to take the latest case to share with you all, so that we don't take cases from 10 years ago and discuss with you all, right? Just double check. All right. Okay, before I start, if any of you have any Q&A, right, I think this one is a live Facebook. It's not like webinar, right? So you can maybe put it into your comment. So if I'm able to see in the comment and it links to some of the slides, then I may be able to answer it at that point. For this tonight live, I'll be using English to explain the slide. So Chinese is not my forte 啦，但是我也可以讲的华语，但是今晚我们 try 英文先 ，OK? This is the first attempt from me. So you start sharp at 8 o'clock. All right. So everyone excited, sharing. Hopefully you all can learn from this sharing as well. So you have any like question first, I think you can put it in the comment box. Huh? Let's see if I'm able to address. Okay, there's one comment. Let me just check. Okay, this is a complimentary comment by Zenwei. Thank you so much. I've not yet speak on the topic. So, okay, just to check with you all, those who are watching, right? Are you all like very familiar with estate administration? For example, wills, probate, letters of administration and all that? I assume a lot of you have maybe done a will, write a will. So just to roughly know your understanding on this topic, so that if I'm going too fast or I'm going too legal on my term, I may slow down, or I will rephrase the way I explain the concept so that you can understand the matter. So we have 3 more minutes here. Okay, if let's say in the future, if you have any like legal issues that you want me to discuss, right? I think you can also post it in the comment box so that I can also do my research. So all of this that I'm sharing is actually, it happens in real life, means that it has been, decided in a court, or some of it are from my past experiences where I had dealt with my clients and all that. Of course, I will have to protect the confidentiality of my client, but in terms of certain story or the practical way of how we go about for matters of estate administration, I think it is okay to do a sharing so that the public can learn from it. Okay, Jason made a very good questions here. Okay, this one, maybe I'll answer that at the end of the slides. I think it is not fair also to promote lawyer. Only lawyer can draft a will and all that. I think also there are certain, some of the senior will writer, they may be able to give you a better will writing planning. Some of, for example, will writer company, they can give you trust, trust, trust is different from will, but it can also be combined with the will and all that. So it depends on your situation. And also, of course, in the service line, it's about the responsiveness. If you call or you ask for explanation, they don't explain to you, or after they have drafted this will sign, then no one gonna answer your phone call, then it's also no use, right? Because your accumulation of wealth happens from time to time. So it is also proper for you to recheck with the agent or lawyer or whoever you get that person to draft the will from you. Okay, if no money need wills or not? No money means you mean cash, or you don't have property, or anything also don't have? Anything also don't have. At least if you're working, you have EPF, right? You put. So it is also, I mean, it's optional. Then you can consider to get a will, even though the will, EPF doesn't, EPF you have to nominate. It doesn't mean that the person that you nominate in the will as your EPF beneficiary can receive it, because the EPF Act prevails, which means whoever you nominate in the EPF branch prevails. Okay, but the reason there are certain cases where we get our client to include the EPF detail in the will so that the executor or beneficiary find it easier for them to locate which EPF branch to withdraw. So it's not for the purpose of overriding EPF nomination. Wow. Okay. Okay, without further ado, let's start the discussion or the sharing tonight, man. I think hopefully can open your mind. All right, today's I would like to just do this sharing on the case of Phua Chun Ming against Haris Phua. So firstly, this is a court of appeal case. So court of appeal case means it is the law. Law means there is already this case being heard in the High Court. So High Court, usually they have a lot of the evidences or witnesses being admitted. So they would go and fight in the court. So this one is actually a dispute where it's not just purely you going to the court where you have a will. When you die with a will, right, you go to the court and apply for probate, correct? So when you apply for a probate and maybe one of the beneficiary doesn't like the content of the will and they go challenge, right? So you will first go to the High Court, because only the High Court has that jurisdiction or power to hear dispute of estate administration. So this case is actually at the Court of Appeal, where one of the party lost in the High Court and they further appealed. All right, so when it is a Court of Appeal case, it is actually the law of this country. So we will decide on certain issue. So all of these are actually quite important for today's discussion. So let's go to the facts. So the facts is actually about a lady. So this lady actually passed away in 2016. So due to some disease, this one I actually cannot pronounce, I don't know why. Okay, disease, due to the blood disorder that this lady had. So what happened, this lady, he had assets. So assets can be both movable, something that you can move around, like your cash, or immovable like your house or shop lots and all that. So based on this slide, am I sharing the slides? Yes. Okay. This lady left a property in Penang where she actually owns half of the shares, and she also has some shares in certain Sendirian Berhad company. And of course, she also invested in the Bursa Malaysia. So those are the public listed shares. So what happened when she passed away? Just make it simple. This lady is a single lady. So the asset actually by right should goes to the there's no one to give, no kids to give, no husband to give, no parents to give. All right. So what happened? So we look at, in this case, who are the people involved to claim from this deceased lady asset? So it's actually the brothers. There's the elder brother and the youngest brother. So the eldest brother is the plaintiff who is suing the youngest brother. So in this case, there are also few defendants, but the remaining two defendants, 2 and 3, is actually the youngest son of the first defendant, and both are the son of the youngest brother, maybe the first son and the second son. So the effects is mainly between these two brothers. So what happened is the plaintiff, the elder brother, is saying that this youngest brother, before this lady passed away, 3 days before that, this younger brother went and transferred this lady's share. Maybe this lady was in the hospital. So this brother went to the lady, maybe in the Penang hospital or something, and asked this lady to transfer her share in Bursa that she has invested to the first defendant. So this lady hasn't passed away at that time. So this plaintiff was trying to say that maybe she was being influenced and all that to transfer to the younger brother. Because subsequently, the dispute that happens is that this case actually has a will drafted by the deceased lady. The deceased passed away. Of course, that will actually has been communicated to them. Okay, but what happened? The original will went missing, So this is also a very interesting case. You've drafted everything, you think your beneficiary gonna inherit, but at the end, once you pass away, no one can find the will. So what happened? This younger brother went to the police station to lodge a police report saying that the will is missing, but they have actually the duplicate will. So when you go and do a will, right? So make sure you also have the original will, duplicate will, and all that, not just one copy of the will. Because once that is gone, it means that you actually don't have a will. No one can locate it. Your executor cannot find it and all that. So the plaintiff is saying that they will want to file a caveat in the court because there's already a dispute. They're fighting now in the court. So the plaintiff is taking the position that the deceased had died without a will. So mainly maybe because the plaintiff knows that the will would exclude the plaintiff. So this is very, very common one. When there's a dispute in probate, usually what happens is the party in the High Court, they will file a caveat against the other party. So the plaintiff is taking a position that if the other side, my sister who passed away doesn't have a will, right, then the law applicable in my sister case should be the Distribution Act. So Distribution Act is actually one act where it governs the situation where there is those who pass away doesn't have a will. But the important section is actually just Section 6. There are also many sections on it. Section 6 would govern how the deceased who doesn't have a will, we call it intestate situation. So there will be a formula. We call it the government's will. The government decide for you, and the government decide this deceased asset can be transferred. If she has a children or parent, then the children would get 2/3, the parent get 1/3. Okay, if there's husband, then the husband get 1/4, parents 1/4, the kids get 2/4 on equal basis. Let's say you have few kids and all that. So principally, the kids get smaller. So the plaintiff in this case is saying that, look back at the facts. This deceased lady doesn't have a family, single lady. So that 3 line, we're talking about the lady's parents pass away, no kids. we look at that another T line here, right? No husband. So it would actually goes to the next uncle or sibling line. So this is why they are fighting in the court right now. So the plaintiff is saying that deceased has no will. So based on distribution act, siblings, these two siblings, should get the assets of the deceased on an equal basis. Because why? If we follow the wills, then maybe the plaintiff doesn't get anything, right? So the high court, now we're talking about the high court, the below court, when they have trial and all that, they call the witnesses to tell their own story. The high court agree that the deceased original will has went missing. The deceased has destroyed the will, even though you say the deceased has written a will before. So the high court held that the deceased has died intestate, which means if died intestate, the Distribution Act would apply, and the position of both this plaintiff and defendant is that both of them would be receiving the asset or inheriting the asset of the deceased on equal basis. All right, this is what I was trying to explain just now. If this deceased lady has a father and child, okay, always remember that you don't need to remember all this formula. Just remember the kids, even like family matter, divorce and all that, right? The best interest of the children should be taken into account and should be prioritized and all that. So you would see that the child in this case would get 2/3, the parents would get 1/3. In a situation where this lady, let's say she has a husband, right? Then the husband would can get 1/4, parents 1/4, the children 2/4. So just remember, children get the most. So if you do not want this government law, right, or government wills to apply under the Distribution Act, then you can opt for wills. That's why people want to draft a will, so that they can let whoever they can choose their successor or the person that they prefer to inherit their asset. Especially, I think business, those who own business, you should really consider a will, because who will take over your company or not? And this slide shows that in this situation, this is the distribution of asset applicable under the Distribution Act, under Section 6. There are many lines there. So the elder brother and the younger brother would get equal shares from the deceased estate. All right, this is okay. The argument forwarded will make it very simple for you all to understand is that when there's a dispute of facts, right, or dispute of this probate, we call it a probate matter within the High Court. Usually they need to be witness. The witness are all this beneficiary, executor, or the person who had witnessed the testator. Testator is the deceased who hasn't passed away. We call him testator. Okay, the witness has to be called, because in a probate matter, the witness has to affirm the affidavit. All right, so this witness has to go to the court and tell the court, yeah, I've seen this lady sign this will in front of me. But in this case, in the High Court, the mistake, I don't want to say it's a mistake, but I want to say the important thing in a probate proceeding, when people fight about Gachan, right, or your estate and all that, you should actually get material witness to come, especially the witnesses under the will who witness the signing of the will by the testator. So if you did not call the witness, one also enough, because a will you need 2 witnesses, one also enough. But if you have 0 witness to come forward, right, then the other side will challenge. They can submit to this court under the Evidence Act, right, for one thing called adverse inference. Adverse inference is under the Section 114G. It means that you don't call this witness to come. Whatever you say, I'm gonna turn it aside, turn to the opposite side. Like the witness, if the witness come to the court, would say, yeah, the testator has signed the will. Under this Section 114G Evidence Act, right, adverse inference is a law principle of law, would say that, no, the testator did not sign the will. So you must bring witness to prove your facts. Otherwise, the other side would argue this in the court. But all of this happens in the High Court level, not the Court of Appeal level. Court of Appeal level means that there is already a finding of facts, and when you appeal, right, you're not satisfied, right, what the High Court had decided, you go to the Court of Appeal. The Court of Appeal would then decide those finding of facts within your appeal records. We call it appeal records. You have all your notes of proceeding in the High Court and all that. Then they will apply and see whether the facts has been decided correctly with the law. So appellate level, like in this case, they only decide on the law. So what is the law, right? In this case, so we explore more. So in the Court of Appeal, I should have actually changed the picture to a different judge. It appears like it is a High Court judge here. So the Court of Appeal had looked into few methods. There are three here. Number one, mode of execution of the will. The will is actually a valid will because the parties has actually submitted the duplicate version of the will in applying the probate. So even though it's a duplicate will, it is still a valid will because it is being witnessed by two witnesses, right, under the will. And number two, the two witnesses had indeed witnessed the deceased signing of the will. And this one, they have fulfilled Section 5 of the will set. So for you to have a valid will, make sure you just need to have, of course, your content. Fundamentally, we are talking about, you need to have two witnesses. Okay, and it has to be in writing. It cannot be oral. You cannot tell me unless you're soldier or Navy. But then the plaintiff did not plead. Plead means, okay, this one is different. In the High Court, when you want to hire a lawyer to fight in the court, right? There is certain document that we file, it's called statement of claim. Defendant would file something called statement of defense. All right. So there are certain facts that you have to tell at the beginning within what we call the court document, the statement of claim, very clearly. If you have another different fact you want to put in, you need to file amendment. But let's say that facts I'll give you an example. The plaintiff says that I have seen the original will. Then they put in a statement of claim. But after that, they found out the facts shows that the plaintiff did not actually witness the original will. Then it is actually a different version of the story. So parties are bound by that first story. Otherwise, the dispute will never end. The party managed to prove that this plaintiff did not have these particular facts or did not manage to prove this fact. Then the plaintiff keep on changing the story. The proceeding in the court will never end. Because the High Court, they all want to finish the matter within 9 months. So, okay, back to the facts. I'm talking too much of the law already. The wills actually is, okay lah, I mean, has two witnesses. One of the witnesses is actually a lawyer. The other one is a friend of the deceased. So the lawyer actually affirmed an affidavit to say that I've actually witnessed the single lady in signing the will. So credibility of witness is actually very important, especially, someone of high caliber. You can have a family member who is a doctor, lawyers, accountant, if they're able to, affirm later on after you pass away in the court within the affidavit, right? Then the court would actually believe, because at the end of the day, the witness, as long as the witness is not a beneficiary, they did not inherit anything from the deceased asset, whatever the witness say will be binding, or the court would believe, because they have no conflict of interest. All right. Okay, the plaintiff brother was arguing few things. I think this one is just it's not a very strong point. They are saying that the signing of the pen, the color of the pen is different. One is blue, one is black. But it doesn't matter what. In a will, as long as it is being witnessed by two witnesses, regardless of your color pen is different color, it is still a valid will. Unlike land office document like MOT, SMP, you need to have a dark ink pen. But this is where those who are more professional, they would come in and advise, okay, I would need you to sign using a dark ink pen to avoid any of this dispute. So these are all the plannings that you need to actually discuss with your whoever, like your advisor or your legal friends and all that. And this plaintiff in this case is arguing the witnesses are not signing at the same time. This is actually no requirement for the witnesses to prove that the witnesses sign at the same time. The witness only need to witness the testator sign at that time. and they can actually attest at a later time. But to prevent all this matter, this is something very practical that I would like to share. Maybe you can put the date and the time when you witness the testator sign. And at the same time, the testator can also put his, after he has signed or she has signed, put the date and the time. Then this argument would never come into place. I mean, this is something that, once you have learned all these, you have read case law, or you understand the matter, then these are the things that you can improvise in your wills so that beneficiary or those who are not happy with the result, right, they don't get anything, then they cannot forward all this argument in the court later on. But preferably, sign your will with a dark ink pen, not ball pen. Okay, one more thing. There's a question. Let's say the will is being witnesses by two witnesses, right? Then what if one of the witnesses pass away? It doesn't matter. Let's say the testator pass away and the executor go to the court and apply for the probate. There will be course paper that we file. We only need one witness to affirm the affidavit. This is under Section 68 of the Evidence Act. So the principle is that we only need the second witness to come forward to the court if the first witness in the affidavit says that I actually did not witness the testator signing this will. Then you need the second witness, understand? So you actually don't need two witnesses. But another level, let's say both witnesses also pass away. What happened? Doesn't matter. Still go ahead and file for the application to extract the probate, but the lawyer has to file an affidavit to state that the both witnesses had passed away. So this one would depend on the court whether they would grant the probate, but on the procedure part, it wouldn't affect the validity of the will, even though both witnesses had passed away. Okay, SD1 is actually the lawyer in this Court of Appeal matter. So when during the trial, the lawyer came to the court as a witness, he just informed the court on the truth of the facts. So the court would also decide in a probate dispute matter on whether the witness is a credible witness by looking at the conduct. When you're giving, you go court, a lot of the, ordinary people would nervous, right, and shake and all that, and speak also. But this SD1, the demeanor is very, very calm, because if you're lying, the court can know one based on your body language. Okay, one thing, the plaintiff, this elder brother, right, also argued that the deceased sister had mental issue, which she had a blood disorder. So even though the deceased had the testator at that point of time has a disease like blood disorder and all that, or cancer, it doesn't mean you're unsound, because if you're unsound, then you can challenge the will was signed because you couldn't make a rational decision, right? But all of this doesn't mean that the will is invalid. Having a has a disease of blood disorder doesn't mean that your will is invalid, because you can still think rationally to sign the will. And that will, when they look back at the date, is also very important. The will was perfected 2 years before the deceased had so-called this blood disorder. So that the fact that blood disorder doesn't affect the mental capacity of the lady who passed away. Okay, of course, this younger brother also done something not clean. He had transferred the deceased share within Bursa, right, I explained earlier, to him before the deceased passed away 3 days before that. But the court still honor the last wishes of the dead based on the content written in the will. It is something that the brother done not that clean, but the court still accepted the fact that the deceased wanted the asset to be distributed to the younger brother. So the original will is gone. You can still take a duplicate will to the court. Okay, here's another scenario. You have the original will, duplicate will, but the signing page of the will is still signed by both sides, right? Because for will, you can only have one original, the other one must be duplicate. What if it is a photocopy version? So the answer to that, yes, you can still use the photocopy version, to apply for the probate order. But then there need to be more explanation before the court in the affidavit to explain both this will has gone missing and all that. Then the witness has to affirm in the affidavit to tell the court, yeah, I actually witnessed the testator sign, and then this photocopy version is actually the version exactly the same like what the testator and sign, and this is also my signature. So the witness is very important when all of your will cannot be located and you only have that photocopy will. So in this modern world, I think I suggest that you just scan, you ask your drafter who have drafted your will, scan a copy of the will so that you can keep a soft copy. I think I made a short video to say that you can also make us like barcode, right? Let's say you pass away, you can get your beneficiary or executor, scan a barcode, and then you can just get your will. All right, I think this is a sharing here. So the conclusion to this case is that the court agreed that the will, the content of the deceased will stand, despite the younger brother applied for the probate using a duplicate version of the will. So I think the elder brother did not get any assets or get a less amount of asset from the deceased will. Otherwise, the brother won't come and challenge and wanted it to be distributed according to the distribution network. So, all right. Thank you so much. I mean, I just want to do I know this is a weekend. I don't want to take up so much of the time. So I just want to check whether there's any Q&A from the public. So that's all for tonight. I mean, I will check whether there's any question from you all, right? So if you have any question, you can actually put into the comment box there. What? That's all? No question? Or is my explanation too clear to you? Okay, so since there's no questions from the floor, right? So I'd like to thank all your time. So do let me know if there's any other like legal so-called topic that you would like me to explore, right? So that we can, from time to time throughout this platform, we can do the sharing with you so that you can learn more. All right. I may be giving another talk on company. So because company is also part of my forte and also tax. So I don't try to do too much. I don't do criminal. I don't do medical and all that. So I just focus in tax and death. So tax and death also involve company, they transfer and all that. Okay, maybe I can just quickly. Mr. Carter, of course, to do a will, anyone can do. I mean, even for me, I can do, a lawyer can do, a will writer, Roxy can do, and all that. So it depends. Maybe you can go and approach whoever that you think that can provide you the will writing service. But you also need to know, you need to understand whether the solution they provide to you, because not all wills are the same. There are certain wills that depends on the criteria that you give them. If you have kids, then the will has to include certain guardianship clause, whether your beneficiary or the house that you want someone to hold it as ancestral house, then there's different clause that we have to put in and all that. Wow, Jason, it is better to do a will at a lawyer firm or will writer. Okay, I don't want to say a law firm is better or a will writing firm is better, but what I can do is a comparison. I think usually lawyer, we just charge you on a legal fee. And then the will that once you have prepared or write for you, after you have signed, we will give you a copy to keep. Of course, we will keep a copy within the firm and all that, just in case you have lose it. And we also don't charge you any, what they call, there are certain, I've heard rumors that they've charged you percentage and all that. So I felt like this is also not fair, because if you charge by percentage, once if you cannot liquidate the asset, then where are you going to find the money to pay those percentage fee, right? But it depends. Some of them may waive you on the percentage fee and all that. Okay, for if you have any concern over will keeping and execution, of course, you would get a physical copy. You will also get a soft copy, and also the will writing law firm or company, they will keep a copy, right? The execution is, that's why it's also very important for you to have a willing executor to act on you. So my advice always to my client is to get more than one executor. Let's say the first one passed away, you will at least have a second option or the third option. So for example, like husband, wife, you can have the wife to become executor. Let's say both pass away, you have your third option, maybe your kids, or maybe your good friend, or maybe your brother, all right, to become the executor. So the execution part is where you then go to the court. Yeah, correct. You can actually write your own will, but formality part and also depends on the element you want to put in, you can actually generate your own will, I think. But the problem is, let's say it doesn't fit your situation, like you want certain element of trust. Then I think for trust part, you need to have a proper clause on that. You need to have a clear subject matter and all that. So wills is not just purely will. Wills also have will trust, testamentary wills and all that. Yeah. And sometimes wills is something for you after you pass away, right? What if you're still surviving and you're 70 something and you need someone to take care of your asset and affairs, right? Then there's certain document called power attorney. Then there's something that you can consider. Maybe this one I can do another sessions on PA. PA, for example, you are old and you can't walk, right? You can actually power authorize your kids to go and take care of the property for you. Let's say receive rented income and all that, and the ownership of the property still remains with you. I've done one PA for clients who withdraw money from the bank account, and the bank actually allows the daughter to withdraw. So these are a lot of estate planning things that you can also consider. So thank you very much. I see that they are actually not much question. Maybe I have keep too much out in the short videos. I think you also learn a lot from it. Okay, so without further ado, I thank you for those who participated. Wow, this one, appointing an executor is foremost important, as the executor you appoint can take away all your asset. Not really. I have to disagree on this. Not all executor can take away your asset, because executor only execute. Those who inherit the asset is still those under the beneficiary list. Thank you, Carol. So thank you so much for your time. I mean, I'll find another day. We have some more interesting topic to discuss then. So okay lah. Thank you so much. Have a good weekend, and thank you for participating and watch this. All right. Bye bye, everyone. Bye bye.